Welcome, everybody. Thank you all for joining today. We have a very important topic, and that's why there's almost 1,000 of you participating. I'm Gary Gartner. I work for Mike Schaefer, Vice Chair of the State Board of Equalization for California, and he represents you in Southern California, everything south of Los Angeles, and he'll be on in a moment to say hello. I'm sitting in his seat in our office where he normally sits for our Board of Equalization meetings to help moderate today, and he'll be on from our other office, his home office, in a moment. So we have experts here today to answer your questions, to really understand how Proposition 19 may impact your family's property, estate, and inheritance. It's very complicated, and we have some experts. We have tax experts, estate planning experts, and others who will answer your questions. We received a lot of questions that you've submitted in advance. And so what we did is we combined as many as we could so we can get to them. We're going to hopefully have about 45 minutes to answer those. And hopefully you'll get further, you'll learn from that. You're welcome to put things in the chat, and we have people who will be capturing that. And then we will have emails for you to contact your assessor if you have other questions. So I wanted to start by sort of having a disclaimer, which is the information presented is intended to provide general and summary information about Proposition 19. It is not intended to be a legal interpretation or official guidance or relied upon for any purpose, but is instead a presentation of summary information. If there's a conflict between the information presented today and the text of the proposition or its implementation, the text of the proposition or legal interpretation will prevail. It is highly encouraged that you consult an attorney for advice specific to your situation. So that's a long way of saying, listen today, learn, and then you need to take your particular exact situation and talk to a tax professional so that you get the right answer in the next week before the deadline, okay? All right, so I would like to now introduce Mike Schaefer, Vice Chair of the State Board of Equalization. Mike was the youngest member of the San Diego City Council when he was 27 years old. And now, next month, he will be 83. And he's the oldest state constitutional officer in state history for the state of California. So here he is, Mike Schaefer. Okay, I guess we're not going to have Mike at this time, but we will in a moment. All right, so now I would like to introduce our friend who is the California's Assessors Association, CAA. He's the statewide president for 2021, and he's our friend here in San Diego, Ernie Dronenberg Jr. He was first elected in 1978. And Assessor Dronenberg he started his career on the school board, the Board of Education in San Diego County. And then he used to be on the Board of Equalization representing the district that Mike Schaefer represents previously. And he was the Franchise Tax Board Chairman and the Chairman of the State Board of Equalization. He authored the California Taxpayers Bill of Rights, and he is a former partner in Deloitte LLP tax practice. Ernie's been in the tax business a long time, so he has a lot of knowledge to share, and his staff as well. And also, Ernie is a veteran. He served in the U.S. Coast Guard. And Ernie and his amazing wife, Marilyn, have 7 grandchildren, which must keep him busy. He can tell us about that. And they live on a 33-acre flower farm in Fallbrook in northern San Diego County. He is an institution in San Diego County and now across the state. So please welcome San Diego County Assessor, Recorder, County Clerk, and President of the State California Assessors Association, Ernie Dronenberg Jr.
Thank you, Gary. I know you all gathered today to hear an institution speak to you, and believe it or not, this is an institution I'm I'm commonly called a legend. I don't know what that means, but I guess I am one because I am so old. But my work in San Diego and statewide has been since November, working hard with the assessors to come up with some answers for Prop 19, where there was many holes where the proposition didn't give instructions, make decisions. And so we put together, the CAA put together a task force, and we started in November, and in 3 short months, we have worked out all the needed language, but we've run into a stumbling block with Sacramento in that the legislature.
Unmute. Now
the legislature.
It says mute. So I guess
other priorities right now in COVID, but we're hoping to have actual legislation that follows our lengthy analysis of the proposition and the holes that need to be filled. So today, the questions that we answer will be based on this task force's results, the answers that they've come up with. And on that task force was not only California assessors, member of the legal staff of the Board of Equalization, and other interested tax professionals to come up with these answers. The assessors throughout the state are anxiously waiting for the legislature to come out with a definite document, but we don't know that we'll make, and you'll hear later about the crucial date of February 15th. But if we don't have the legislation, we will have a set of standard practices that we're going to follow. The idea is that we want to have consistency in application of Prop 19 from the top of the state to the bottom of the state. I appreciate the remarks, but what's important is we get to your questions. So I will then thank Mike Schaefer for hosting this today, and turn it back to Gary to introduce the other assessors that are with us today. Gary?
Gary, you need to unmute your microphone, Gary. Unmute your microphone.
Sorry. Okay, sorry about that. I wanted to tell you all that Ernie is a legend because we put his name on the, they put his name in Sacramento on the conference room that is adjacent to the Board of Equalization board meeting room in Sacramento to honor him for all that he's done over many years. So thank you so much. And we look forward to solving these problems with the legislature with you, Assessor Dornenberg. So now I'm pleased to introduce my boss, Mike Schaefer, who I said earlier at 27 was the youngest council member in the city of San Diego, and at 83, next month he'll be 83. Mike is the oldest constitutional officer in state history, and he represents everything south of of Los Angeles. So here is Vice Chair Mike Schaefer.
Good afternoon. Can you see me? I can only see the general screen.
We can.
Well, you can't see me?
We can,
but you can hear me. Okay. Well, thank you and good afternoon, everyone who has come to be with us today. I'm proud to be your elected representative on District 4, which is the counties of San Diego, Riverside, Imperial, Orange, part of San Bernardino County. I suspect that most of you on the call are in our District 4. I'd like to welcome you to the virtual town hall today, where we're going to discuss Prop 19, which, as you know, was passed by the voters a few months ago. It will change the structure of property that is to be inherited after February 16th, 2021. And since that's right around the corner, it's appropriate that we speak about this issue today and solve any of the confusion that exists. My goal today is to help us find answers to our concerns. We're joined today by several assessors and a panel of attorney experts to review inquiries and answer your questions. I want to thank all the people in the audience that sent questions to us to help us have a good program. Knowing what you are most concerned about helps us focus today, and we can answer as many of your questions as possible. I'd like to thank my staff in particular, Chief Deputy Gary Gardner, who you've seen before, my new Assistant Chief, Will Rodriguez Kennedy, for all their hard work. I have our legal counsel in Sacramento, Sue Blake, and Michelle Harrison, my constituent affairs managers, and the wonderful communications team from BOE for putting all this together. It involved a lot of organizing in a short period of time, and let's get on with the program. Thank you.
Thank you so much, Vice Chair Schaefer.
I don't hear anything.
We will be getting to the presentation as soon as we have two more quick introductions for the assessors who represent our District 4. We next hear from Peter Aldana. He is the Assessor, County Clerk, and Recorder for Riverside County. He was elected in June of 2014, and he's been with the Assessor, Recorder, Clerk's Office for 25 years in a variety of appraisal, supervisory, and management positions. And Peter is a lifelong resident of Riverside County. He earned his BA from California State University, Fullerton, and his master's from Azusa Pacific University. And he's a significant member of the California Assessors Association and other associations in the state. And he's a very nice guy, and we enjoy working with him a great deal. Peter Aldana.
Thanks, Gary. I'll make it really brief. Thanks for having me here today. And I appreciate Board Member Mike Schaefer putting this together, and your staff putting this together on a very important topic on very short notice. And Ernie, thanks for leading us off. I know we've had a lot of collaboration between the BOE and the Assessors Association on interpreting and implementing Prop 19. So I'm hopeful that since my neighboring assessors like Ernie and Robert are here today, that we're going to have a consistent approach to implementing it and serving our citizens. So I much appreciate that. And also, though we're not on the panel of experts doing the talking today, I do have Sean Downs with me, my Chief Appraiser. So if the panel or any citizens have any specific questions regarding how Riverside County might be implementing Prop 19, Sean's here to help. He's the answer guy. So again, thank you, Board Member Schaefer and staff, and I'm sure we're all going to learn a lot today. So thanks.
Thank you so much, Peter. We appreciate it. We appreciate you and your office, and enjoy working with you very much. Next, we're going to hear from our friend from Imperial County. That is Robert Menville. He's a lifelong resident of Imperial County, who's been serving the public for the past 24 years as a property tax appraiser and now is county assessor. He also was elected assessor in November of 2014. So both he and the Riverside County Assessor, Peter Aldana, were elected at the same time. Robert's background is in agriculture, of course, because he's from Imperial County. He was raised on a farm near Calexico and worked on the family farm and in local agribusiness operations prior to joining the assessor's office in 1992. And he's a graduate of Calexico High School, Imperial Valley College, and California State Polytechnic University at Pomona with a degree in agricultural business management. And Robert is just a joy to work with. We talk often, and he's doing a great job for the citizens of Imperial County. Assessor Menville.
Good morning. Can you hear me?
Yes.
Good morning. I appreciate being invited to participate. The contact information for our office is on our website. If you do the math, I've actually been here 28 years. My bio is not been updated as has some other information not updated on the website, but I'll take care of that. Here to answer questions, specifically anything having to do with the family farm issue in Prop 19, which has caused or created many inquiries in our office due to the number of family farms that are here. Many of these are immigrant farmers that came here in the turn of the last century. Families that continuously farming for 3 generations, and we're quite concerned about the changes in Prop 19 bringing to agriculture land transfer. So I'll be happy to answer those as best I can, since we do not have the language yet. So a lot of what I will be able to tell you is just based on the CAA Proposition 19 committee that we're working on as part of the task force that John mentioned. Appreciate being invited. Here to answer your questions and here to serve my property owners.
Robert, your microphone is a little choppy. I don't know if you might want to call in or double check your microphone in the off time while the other panelists speak.
Okay. Well, I'll get rid of
Yeah.
this thing here. I'll just ditch it.
If you could call
Yeah.
in. Yeah.
Okay. Yeah, it was a little bit choppy, but we heard you somewhat. Okay, next we're going to start our program. So I'm pleased to introduce Jordan Marks. Well, actually, I'm going to tell you a little bit before I introduce Jordan Marks. What is the California State Board of Equalization? Was created in 1879 by a constitutional amendment. We're responsible for ensuring county property tax assessment practices and making sure that they're equal and uniform throughout California. The Board of Equalization directly assesses the property of regulated railroads and certain public utilities, collects the private railroad car tax, and is responsible for the alcoholic beverage tax and the tax on insurers. There are 4 equalization districts with 4 elected board members, representing approximately 9.5 million Californians each. The state controller, Betty Yee, is elected at large, and she serves as the board's 5th member. Next slide. Market value versus assessed value. This is very important, and Jordan Marks will be explaining this in more detail. Market value is the market-driven price of any property at a given place and time, or what the price of a home could be sold for. The assessed value of the real property is determined by the county assessor at the time the property is purchased, generally the sales price. The assessed value will then become the base year value. Okay, so now I'm going to introduce Jordan Marks. Jordan is a taxpayer advocate for the Office of Assessor Dronenberg, San Diego County. In his position, he assists taxpayers with navigating property tax issues, and he has successfully resolved over 1,000 taxpayer cases since joining the office in December 2017. Since Jordan joined the office, the San Diego taxpayers have received a record high property savings in 2020, topping $236 million. Thank you, Assessor Dronenberg and Jordan and the team at the assessor's office. Jordan leads the office's countywide award-winning educational outreach program, and he is a licensed attorney in California and was recently recognized by the San Diego Business Journal as one of their 2020 Next Top Business Leaders Under 40. He's also a father of a beautiful baby boy with his wife. Jordan Marks.
Thank you so much, Gary. I really appreciate you being hosting this event, and Vice Chair Schaefer and our friends at the North San Diego County Realtors. And our friend Will Rodriguez is going to run the slides for me right now. Oh, there we go. Actually, we are all technically Zoomed ready today. So thank you so much, Gary, and thank you so much for welcoming us on Prop 19. This was an initiative passed in November of 2020, and the initiative was to help severely disabled seniors, wildfire, natural disaster victims. I think they even tried to put unicorns and lollipops in the title of it just to make it really interesting to the taxpayers, but there are some impacts that are happening to you very quickly. And this is a voter initiative, so that means you passed it, and we're gonna help walk you through it as best as possible. I am Jordan Marks. I am the San Diego County taxpayer advocate. I work for Assessor Dronenberg, and our job is to ensure fairness, provide education, and correct systemic issues. So, oh my God, you guys have been waiting for Prop 19, and now you're seeing Prop 13. What's that about? Well, in order to get into Prop 19, you have to understand Prop 13. That is the basis of California's property tax system. Prop 13, which was passed in 1978, was an agreement between you and the government. That's you, the property purchaser, and the government that says, when I purchase a property, I agree that I can afford to pay 1% of the assessed value, or that's the purchase price in an open and fair market transaction, as long as I own the property. So if Gary went and bought a property for $100,000, he says, hey, I can afford to pay $1,000 a year. You're doing the numbers, that's 1% for the life that I own the property. And Prop 13 put a cap on taxes and says that assessed value of $100,000 can go up 2% per year. So if Gary's doing Prop 13 numbers and he goes, this is great, it's affordable, it's predictable, it's budgetable, I know my taxes at the most can go up $20 or 2% to $1,020 the next year. And it can't be changed unless you, the voters, decide to change it. Here's a visualization of Prop 13 and Prop 8. You're going to need these for today. So if we have our friend Assessor Robert Menville bought his house for $450,000, congratulations, Robert. And the price shoots up to $600,000, like we haven't seen that here in Southern California. Your taxes would have gone up $1,500 the next year. That's crazy. It's unaffordable. It's unpredictable. And you can't budget for it. But Prop 13 locked in. And remember, it keeps you at that smooth black line, that 2% increase. Now, I know all of us have realtors out there that say the prices only go up, but sometimes they come down. And we saw that in 2008. We saw the market crash. But don't worry, the realtors also tell you to hold on long term, and it makes it worthwhile. You'll see it in the end. But Prop 8 was passed after Prop 13 by the voters because they're like, hey, if the price goes below my assessed value, below that black line, I should be able to reduce my property taxes. And that's what it does. And so in San Diego County in 2010, when the market crashed, we actually lowered the property taxes for 300,000 property owners. And then as the market comes back, you can see it, it gets stopped at that star. That's the cap where it limits it. That is what we're talking about, Prop 13 today. And so let's get in now that you know. Oh, wait, one more thing. You said, Jordan, assessed value. Where do I find my assessed value? Well, you can go to your treasurer tax collector websites in any of the counties you're in. In San Diego County, you can see it's sdttc.com. And right there on the tax bill, you're going to be able to see the assessed value. I underlined it in red. So this property here, the net taxable value, or what we're talking about today, assessed value, is $252,993. Okay, you're running the numbers in your head and you're like, what is that? And Vice Chair Schaefer says that's a $2,500 tax bill. That's right. But if the property is worth $1 million, guess what you're paying based on that 252, that locked in lower rate. So today we got a number of things that we're going to jump into, and I'm going to be getting into the rules of Prop 19. But before we do that, I'm going to talk about the current rules in place. In the meantime, I just want to introduce a friend of mine that I brought along, the Chief Deputy Assessor for San Diego County, Jeff Olson, and he's going to be answering questions in the chat box as you go along. And you're going to have questions, so drop it in the chat box. We're going to help you. And Sue Blake, expert from the Board of Equalization, in the chat box. And we also have a great attorneys that are coming up that are helping you. Put the questions in the chat box, and we'll be answering those for you as we go along. Okay, so let's get in. Prop 19. It primarily impacts two areas that we're concerned with today. The first one is the parent-to-child transfer. Now, it's also have a grandparent-to-grandchild transfer. Why do we have that? Well, when the voters passed the parent-to-child, there was a bunch of grandparents out there that are like, I don't really like my kids. I want to give it directly to my grandkids. But they were like, you can't do that. Only in the unfortunate circumstance where your kids have passed can you give it from a grandparent to a grandchild. I'm not telling you to go out and kill your kids because you love your grandkids so much. That's a district attorney issue. Don't do it. But if that unfortunate circumstance happens, you can give it directly to your grandkids. Otherwise, it has to go from parent to child and then from parent to child. Okay, the second one that we're going to talk about is the senior exclusion from reassessment. Those are the seniors out there that are like, I need to move, but my taxes are going to be too high. I don't want to move. We're going to talk about it. We're going to help you today. There's two other areas that we'll get into. Those are the Prop 110, severely and permanently disabled. Those are the same rules that are going to apply to the senior exclusion, okay? I just want you to know about it. What that means is if for some reason in your lifetime you become severely or permanently disabled, the law allows you to switch residences to accommodate you or make improvements without your taxes going up. That's a car accident. That's unfortunate circumstances. We have veterans that are coming back from Iraq and Afghanistan that had a 3-story condo. They need to move into a 1-story ranch house. We can help them. We even had this really weird situation. We had a taxpayer all the way out in the desert. They were in the desert, okay? And they became allergic to dirt. I never thought that was possible. But you know what? We had a doctor that said they became severely and permanently disabled because of their allergy to the dirt. They had to move. It's weird, but we helped them. That's what we do. The second thing that I want you to know about is the disaster relief. Okay, under Prop 19, it's fantastic because it makes it statewide. Before, you had to figure out whether the county would allow you to come in. So for example, we had taxpayers that unfortunately lost their homes in the Butte fire in Northern California. And it's crazy. Just imagine the city of, in San Diego County, we imagine the city of San Marcos. In Riverside, imagine the city of Corona. In Imperial, imagine one of the largest cities. You know, these cities, if they burn down, what happens? You don't have housing stock to go to. And what they were doing, they were living in their neighbors' yards with a twig and a tarp for $1,200 a night. It was unsustainable. So some of them said, I don't want to deal with these Northern California wildfires. I want to come to San Diego. And so we helped them, but we had to pass a rule and adopt a legislation to allow us to do so, and we did. But now it makes it statewide. So if you lose your home to a wildfire, a mudslide, I thought the winds were blowing so hard we were getting hit with tsunamis the other day. I mean, who knows? In 2020, I thought maybe locusts because we were hitting biblical proportions. If the governor declares it an emergency and it tears down your house, or you have more than $10,000 in damage, we can help you. Call us. That's what we want you to know. And that's why Vice Chair Schaefer made it so important to have Assessor Dronenberg, Assessor Aldana. We have assessors from Imperial County, assessors from Orange County that are there. That's the local offices wherever the property resides that you need to talk to. And so you're talking to Assessor Menville, where they're going to help you out. And if you're in San Diego, call us. We're going to help you. Okay, let's get into Prop 19 because you need to know what's going to happen, Jordan. I'm on my pins and needles. Here it is. Up until February 16th, that's the operative date. Don't have to mark it. You know why? Because Gary is fantastic. He's our friend. He's going to send you the slide. You don't have to write down the date because it's in the slides. But I will tell you things that you need to take notes of, but not this. It's in the slides. Okay, so the current rules. You can give your kids unlimited you can give them unlimited assessed value on the primary residence. Not market value, not what it's worth today, but the assessed value. That's the number on the tax bill. So look at your tax bill. Doesn't matter what the number is, whatever that is, you can give it to your kids. No matter what the market value is, you can give it to your kids. There's no requirement that the kids live in the property. And you also today, up until February 16th, get to give your kids $1 million of assessed value. That's the number on the tax bill for all non-primary residential properties. Jordan, what's a non-primary residential property? We'll get into it. Hold on, we'll get there. That's what these look like. A non-residential property is a business storefront, your restaurant property for your small business, a gas station. All of these, as long as the assessed value is less than 1 million total. So for example, if you went out and bought a property for $250,000, you're running the numbers at 1%, because remember, that's how we do property taxes. That's a $2,500 tax bill. If the property is worth 1 million, and if you gave it to your kids without this benefit, they'd be paying $10,000 in property taxes. But because you gave them the assessed value, because it's not the full 1 million, you save $7,500 in tax increases on your kids today, before February 16th. Okay, the second property, let's say your kids went to college at UCSD, welcome to San Diego, and you went and bought them a condo for $500,000. That's what the assessed value is, and it's worth $1 million today. Well, now you get to give your kids that $500,000 value because $250,000 from your business and $500,000 is less than 1 million. On that property, you're going to save them $5,000 a year in tax increases. This is wealth building. This is wealth opportunity. These are your families growing and making it here in San Diego and Southern California. We want you to thrive. Okay, so Jordan, why don't we talk about that primary residence deal again? Great, thank you so much, I appreciate it. So Sue, she lives in Northern California now, but we'd love to bring her down here. So let's say I get her into a house in La Jolla in 1990 for $100,000, great buy. All right, over time that 2% increase goes up. Now it's at 160,000 of assessed value. That's the number on the tax bill. But the market value, that's what your realtor tells you it's worth, is $2 million. That's awesome. You made this money. It's great. Your tax bill is $1,600, but if you bought it today at $2 million, it would be $20,000. But because you get to give your kids that low assessed value, that $1,600 tax bill, they're going to save $18,400 on this deal. That's huge. That's wealth building, and they get to stay in the primary residence. Now, what happens after February 15th? These are the changes. This is what you have to know is going to happen. These are what you have to weigh out. One, on the primary residence, you now get to give your kids the assessed value plus $1 million of market value. So remember on the other one, I was talking only about assessed value. Now it's assessed value plus market value of $1 million on the primary residence. 2, your kids have to live in the property. 3, remember that $1 million of other value? It's gone, wiped out, sorry. And then 4, they have to make it their primary residence. They have to get a homeowner's exemption in 1 year. So I know some of you recognize my friend with me, the dude who's on the screen, Jeff Bridges from the Big Lebowski. And the dude is the reason why this rule even came up. The dude over here had a really famous Hollywood family. They bought tons of property in Malibu, or we like to call it the Boo when you're from Los Angeles, okay? And he's hanging out. His property's worth $30 million today. He's paying $5,000 or $500,000 of assessed value because his parents gave him their low tax base. So he's paying a $5,000 tax bill on a property somebody else would pay $300,000 today. And guess what? He's renting it out for $16,000 a month. Some people are like, that's a reason to get rid of this benefit. It's being abused. Well, as you see with your family, you're not the wealthy Bridges family, but even the dude after February 15th must abide by these rules. So just remember that. After February 15th, the dude must abide. Okay, here's the deal. Let's look at what that transfer looks like for Sue after February 16th. That same home, $1,600 tax bill. We take her assessed bill. That's the number on the assessed value. That's the number on your tax bill. You add $1 million to that. So now it's 1.16. You deduct it from the market value of $2 million. That difference is called the excess. Now you're going to have an $840,000 of assessed value, or at 1%, an $8,400 increase. You add that to your old tax amount, and that's your new tax bill, $10,000. So before, you could have given your kids $1,600. That's before February 16th. After February 16th, that same tax bill is going to turn into $10,000. By the way, remember that other property, that storefront that you got in that condo? No longer can you pass those low tax bills to your kids, those tax values. Now they have to pay it at market when you give it to them. So those tax bills now gone from $7,500 to $20,000. That's an increase. And that's what they're going to be paying every year. Now, I know some of you are like, I know where La Jolla is. I don't have a La Jolla house. You know, in some cases, you're like, you think that's the exception and not the rule, but there's a lot of you out there that have really taken the time to invest in having a family home that has gone up a tremendous amount of value. I mean, the real estate market's hot. It's going to hit 8%, I think, this next year in San Diego County alone, going up. During a downturn, it's crazy. But this is what we think is going to happen in most of the market. Okay, so for most of they're thinking, I'm going to give this to my kids. Let's say Sue now bought a $300,000 home in University City. Okay, that's in San Diego, one of our more moderate neighborhoods. Over time, 2% increases, $420,000, and at 1%, that's a $4,200 tax bill. Okay, the property's gone up in value to $1.3 million. Good on you, Sue. Good investment. This is how you figure out if the taxes are going to go up. You take that assessed value, the number from your tax bill, and you add $1 million to it because it's market value. So now you're looking at 1.4. If that number is greater than the market value, then there's no tax increase. So because it's only worth 1.3, and that's less than the 1.4, the assessed value plus the million benefit, the taxes for her kids are going to stay the same. But now the kids have to move into the property. It must become their primary residence. And if they move out, we believe they are going to lose that benefit. I think I just heard 500 people go, what? I think I just heard 1,000 people go, what? The guy from the government said, we believe? Yeah, this is where we're at. I want to explain it to you. The initiative passed in November. As Assessor Dronenberg explained, since November, we've been working on this to pass legislation to get more definitive rules. The Assessors Association, the Board of Equalization, all these people that you're like, am I listening to another government official? But we're all working together and we're all important to you in protecting you and keeping this as taxpayer friendly as possible. But based on what we're seeing, and we are at the tip of the spear, you are working with the best of the best. Assessor Dronenberg's got 40 years of knowledge. I know Jeff on my team has 30 years. Sue Blake, Vice Chair Schaefer, I mean, all of us, you've got almost 1,000 years of knowledge, and we're all telling you that we think that there's a good chance that this is going to get passed with legislation that's going to say, if your kids move out of the home and it's no longer their primary residence, that they're going to get reassessed at the time that you gave it to them, and they're going to lose that benefit. So when you're talking to yourself and thinking about it, you need to ask yourself, are my kids going to live there? Do they plan on renting it out? These are the questions you need to ask. But if they're under that assessed value plus $1 million and there's no property tax change and they're going to live there, you're good to go right now. Now, I know that Assessor Menville's like, what, Jordan, what about the family farmers? Okay, Imperial, hello, we have tons of farmers. Well, so do we in San Diego, Robert. So come on over. We've got some great coffee farmers. They get an extra benefit. So the Farmers Association, when they are making this bill, said, hey, we need to protect the family farm, milks, fruits, vegetables. So the family farmers got $1 million of assessed value on the family farm portion. Now, here's the cool part. If they act now, I know I feel like I'm one of those TV salespeople. Act now. Well, here's what do. Act now, and you get the unlimited primary residence up until February 16th. You get the other $1 million until February 16th. And then after February 16th, they get an additional $1 million for the family farmland. So here's what you know. If you know a family farmer that's trying to keep their taxes low so they can make farming affordable, call one of your assessor offices. We're here to walk you through this. We're here to help you through these complex transactions. Okay, remember I talked about the homeowner's exemption? We're really excited to help you with that. That is the way that we know under penalty of perjury, you're saying, I am the homeowner. This is my primary residence. I live here. You get a $70 benefit for doing that, or $7,000 off your assessed value. In San Diego County, you can go to our website and file it online, or you can go to any of the assessor's websites and you're going to get the information at the end. You need to file this within 1 year. This is one of our mayors. She did not have it, Raquel from Lemon Grove. She went to her tax bill and said, oh, I don't have that word homeowners and the word 7,000, number 7,000. That means she's not getting it. And that was 3 years ago. So now she's saving $210. She's going to get a bottle of wine and a steak tonight and say, celebrate, I got my homeowner's exemption. But you need it to get that after February 16th. In California, we also have another homeowner's exemption. One of them is specifically for our disabled veterans or their surviving spouses. So if you have a disabled veteran, 100% disabled, VA rated, 100% disabled, unemployable, or they are the surviving spouse, they can get up to $147,000 or $1,475 off their property taxes assessed value annually. Also, if they happen to be low income, where their income of their family household, everybody there is less than $66,000, they can save an additional $600. It's over $2,000 potential savings for our disabled veterans. And these are the folks that served our country and really, they deserve it. And so we're proud in San Diego County, we've been making a really big effort. In 2018, we had 5,000 disabled veterans in our program qualified. Through our help of the realtors and also through the great community members referrals like you, send them to any of our assessor offices. We now have 11,000. And in San Diego County, those veterans are saving over $16.5 million annually. That's the same as a homeowner's exemption. You get one or the other. If I was the veteran, I'd take the $1,500 over the $70. It's no brainer. We're going to help you do it and make it easy as possible. Okay. Here's my tips and reminders for the parent to child transfer. One, it must change ownership. So I know some of you are hearing out there that I have to record by February 16th. I'm only talking for San Diego County now. You need to check with your individual county. My boss, Ernie, is the assessor and the recorder. Great, it's easy for us to coordinate. And so if in San Diego County, you notarize and deliver the deed, that is a legal change of ownership, and we will go by that date. Now, I know some of you are like, Jordan, how am I going to deliver you the deed by February 16th? You don't deliver it to me. You deliver it to the person getting the benefit, or your kids in this case. They need to record it afterwards. And before February 16th, they have to file a Prop 58 parent-to-child form. Don't wait to record. The best to do is to record before February 16th. But if for some reason, and I know we're closed for over-the-counter services because of our health officers, you don't get it in on time, don't lose your hair. Okay, I have some left still. I don't want to lose it. Don't lose yours. Okay, remember, before February 16th, you have to file your parent-to-child Prop 58 form after you record the deed. After February 16th, you need a homeowner's exemption now and a parent-to-child transfer within 1 year. Here's a big tip. I know some of you are like, I love my kids. I want them out of the house, but I love my kids. So I'm going to help them buy a property. I'm going to sign on with them. And you may or may not have taken part of the title. You may not realize that. If you did that, now is the time to come off title. You can use that other million of assessed value to come off title without your kids getting reassessed. Otherwise, when you do it later, they could have their taxes go up. Lastly, everything that I'm talking about, you're like, this guy's funny, he's great, he's nice, and he's also from my county assessor's office implementing California property tax law. That's right, I do California property tax rules. We do not do IRS and federal laws. You need to actually consult an IRS professional because there will be tax implications. That's why Vice Chair Schaefer said, Jordan, let's bring some attorneys in. And they brought in some great folks that know IRS rules, and you're going to hear from them now. But make sure you're consulting yours because every detail matters. And I know sometimes you're like, oh, I only have a small house. And then it turns out to be Wonderland that you bought from Michael Jackson, okay? Yeah, I mean, seriously, every detail is going to count. So please, you have to work with a professional to look at your specific situation. Now is my absolute pleasure to introduce from RJS Law, we have their principal and CEO, Ronnie Shamoun. He's also a professor at the University of San Diego. He is on the top 10 list of everything that is a legal professional can do in San Diego County. And also, he is one of the main leaders at the University of San Diego School of Law, and he hosts their major tax conference every year. Along with him is his co-chair from RJS Law, Ryan Malloy, over their trust and estates practice. So please welcome Ronnie and Brian, and they're going to jump in with you and talk about IRS tax implications and also trusts and estates. Thank you, guys.
Well, hello, everyone. Thank you, Jordan, for the wonderful presentation. For all the audience out there, we are very blessed and fortunate to have an amazing county assessor recorder's office. You would think that they are not on our team, but they are on our side. This was a proposition that was approved by the voters. We voted for this in San Diego County, and they're out there trying to inform us of what is going on and are out there lending a helping hand and will continually help us from now until February 16th. It is important. There's a lot of money at stake. I'm going to cover just a few of the major topics. I'm going to leave it up to Brian to continue this on. There are three considerations right now whenever you do have a piece of property. You could sell it, you could gift it, or you could wait until you pass and do it at the time of death. A while back, before the estate tax exclusion and gift tax exclusion was raised to $11+ million per person, then there were times where there would be an incentive to sell a property to a family member at fair market value. If you had a high estate and you were above the exclusion, there were times where it would make sense to sell. But in this case here, with the gift exclusion and the estate tax exclusion, it makes no sense. This would be the time right now, because if you do sell a property right now to your children, you will end up paying the capital gains tax on that sale, and it wouldn't make any sense. So now is the time to gift it. A gift tax right now, you could gift up to $11.7 million per person. Before they used to have a gift tax exclusion that was about $1 million. But now the gift tax exclusion matches up with your estate tax exclusion. You could basically write a check, transfer the deed, transfer the basis. The basis will transfer to the recipient. So there'll be no capital gains taxes and no taxes to the person. That's the way to do it. That's why everybody's contacting any sort of estate planning attorney, any attorney that will assist you in transferring the property. What happens is, it's very simple. You fill out a deed, you fill out a gift tax form, you record the value of the property, and that will transfer. The assessed value for property taxes will remain the same based on the assessed value, but the gift will have to be its fair market value. Anytime there's a transfer between a family member, it must be fair market value. So that is the difference. The assessed value, what Jordan was talking about earlier, is going to be the value for property taxes that gets sent over to you. But there will need to be an appraisal on that property if it's to a related party. And that fair market value will be the value that is being transferred for the gift from the parent to the child or whomever. And the basis of the property, whatever the basis is, basically the purchase price, obviously less any depreciation plus improvements, but that will get transferred to the recipient, so that when your son or daughter sell that property, they're going to have that gain between whatever their basis was at that time. So it's very important to contact a tax attorney, fill out the gift tax exclusion, and take advantage of the property taxes. And now Brian is going to go into some of the considerations with the transfers. I just wanted to give you some kind of high level, just general information about gifting. But you will need an appraisal, and it must be fair market value. You cannot do it without some sort of third-party valuation. The reason is there's a lot of impropriety that happens between family members. You could gift or sell any property at any value to a stranger, but when it comes to a family member, it's going to have to be the fair market value. But that's different than what the assessed value is, what Jordan showed you. That's the value that's going to go down. So property has an assessed value of $200,000, but it's worth $1 million. You're going to get the $200,000 property tax transfer, but the $1 million gift will have been given to the child or whomever that you are giving the property to. So now I'm going to give it up to Brian to go over some other considerations, and feel free to shoot my office any email, or obviously the panelists right now if you have any follow-up questions. But go ahead, Brian.
Sure, thank you. So building on what Ronson said, for income tax purposes, you have a choice of gifting it during your lifetime versus passing the property upon your death. So if you gift it while you're alive, then the property tax basis will carry over to the child. However, that there's no step up in basis. So the cost basis transfers to the child. So if your child sells it the next day, then they're going to face a capital gains tax. And the capital gains tax rates are 0, 15, and 20%. And the amount of tax also depends on how long the child sells, how long the child holds it. So, even though there is a capital gain in that situation, we still have the $250,000, $500,000 capital gains tax exclusion if you use the property for your principal residence the last 2 of the last 5 years. And so, what happens if you've already used that? Well, it's okay, because you can use it an unlimited amount of times, except you can't use it more than once in the same year. So if you live in a property, you have 2 properties and you live in it 2 years, then 2 years, you just can't do it in the same year. So it becomes a cost benefit analysis of capital gains versus property taxes, and of course what your plans and what your family plans and your goals are. So going back to the gift tax, as Ronson said, the estate tax and gift tax exclusions are the same now. We're at $11.7 million. It's been indexed to inflation, so it'll increase each year until December 31st, 2025 is when the Tax Cuts and Jobs Act is scheduled to expire. However, the estate tax and other taxes are in you know, who knows what's going to happen for each administration that's going to happen. So there's been a lot of talk about tax policies that'll be changing. And so the current tax policy projection is that the estate and gift tax exemption might go down to 6 million in 2026 and may go even lower than that to $3 or $4 million, as well as, you know, there's talk about eliminating the step up in basis, the step up altogether. So, you know, and the step up in basis also includes all property. So not just real property, it includes, you know, stocks that you inherit too. So that'll affect a greater amount of people. So now next we'll go to estate taxes. So if you pass away with owning property above $11.7 million and you're just by yourself, then your estate's going to be subject to estate taxes. If you're a married couple, you can pass away with $23.4 million. And after the first spouse passes away, there's something called portability, in which the surviving spouse can use the decedent spouse unused amount of the exemption. So essentially the surviving spouse can use up to that amount. So when you inherit property, you do get the step up in basis, and you also, there's no income tax issues. And so like we said, you know, estate taxes, that's always a tricky issue, and it depends on the administration. So there's likely going to be some kind of tax legislation within the next 4 years, but we just don't really know what that's going to be right now. And, you know, as we all learned in 2020, you know, expect the unexpected. We can't predict much at all these days. So,
Well, Brian, so it sounds like if we lose that step up in basis, it can cost these taxpayers hundreds of thousands of dollars potentially, versus the savings of a few $1,000s a year on property taxes. Is that right?
that's correct. So,
That sounds like a big thing to weigh. And it sounds like it gets really complicated. They need to talk to their IRS professional to lay out every single detail related to that. Is that fair?
absolutely. Yeah, so it's very tricky, it's very complicated, and there's a lot of moving parts. Each situation is very different, and so, you know, the advice will differ, you know, per person. So,
Wow. So is there anything that somebody can do to protect both the capital gains, or the step up in basis that's so valuable from the federal taxes, and also preserve their low property taxes here in the state of California?
Sure. So there's a few vehicles that we can possibly use right now, including some trusts, some variation of trusts, as well as certain business entities. And there's also other ways.
Before we get into the trust, do you have any tips or recommendations that you want to share with our audience? And then maybe we'll jump right into the estates and trusts.
Well, it's always going to be the ideal situation now is if they pass away, they're going to get the best of both worlds. And so if you inherit it at this point in time, now, you know, if you also gift property during your lifetime, you have to take into consideration, you know, how much can you gift? How much can you afford to gift? Because, you know, once you gift something, it's out of your hands completely. And, you know, it's really hard to get something back, especially if it's valuable. Also, you know, if you give property to a child, you know, are they financially mature enough to handle a sizable amount of money? Is the property going to be subject to the child's any divorce proceedings, or if he or she gets in a lawsuit, and things of that nature? So it's a lot to think about.
Well, I'm ready to go out and get adopted by somebody that has a $23 million estate. But actually, under the California property tax rules, if you're over 18, that doesn't count. But let's jump right into the estate planning side, and we appreciate if you can go over. I know a lot of folks out there have their properties already in a trust. Do you mind talking about what that might look like under Prop 19 and how that impacts them?
Sure. So revocable living trust, a revocable trust is essentially a contract between you, the settler of the trust, and the trustee who manages the trust. And usually you're the same person. So it's not a change of ownership because it's an extension of yourself. So, you know, for having a revocable living trust, if you have a real property, it's always ideal to have it in a trust because it'll avoid expensive and costly probate proceedings. Right now, a vanilla probate, so to speak, can last around 18 months in San Diego County. I've seen probates that have been over a decade. So, you know, properties locked in the courts, and it can be very messy. And so having a trust administration is usually less expensive, and it's takes less time to complete. And it doesn't trigger a change of ownership, like we said, because it's just handing it over from yourself to yourself as trustee. So revocable living trust, you don't have a separate tax identification number. You're just using your own social security number. So it's not a separate legal entity. So if you die and transfer the property and your kids get it before the 16th, then you're in the parent-child exclusion. You're within. So next, going into irrevocable trusts, there are some irrevocable trusts that we're looking at that can be used to get the best of both worlds here. Now, with irrevocable trust, you have to understand that, you know, by definition, if you create the irrevocable trust, you cannot amend it or revoke it because it's irrevocable. So there are very small situations where an irrevocable trust can be amended or revoked, but for the majority of time, you cannot revoke it. And so once you transfer the property to the irrevocable trust, it's no longer yours. So that does trigger a change in ownership because you no longer own it. The trust, which is an irrevocable trust, and it also has its own separate tax identification number. So it is its own separate legal entity, and it does file its own separate income tax returns. So for purposes of not to have the benefits of Prop 19, you have to, it has to be out of the hands of the parents. So it can't benefit the parents who created the trust. And just because it's irrevocable doesn't mean it qualifies, because there are many different types of irrevocable trusts. And there has to be specific language in revocable trusts and irrevocable trusts. There are some situations where if you do have a revocable living trust, there just has to be very specific language. And if that language isn't in there, then it should be amended. But if the amendment's not done prior to the 15th, you might be out of luck, because that's the date in which the assessor will look at it. So, but the irrevocable trust is, well, different types of irrevocable trusts for different situations. And so it really depends on the circumstances, and it has to be very particular, because the devil's in the details, and it's essential to work with someone who has a really good relationship with the assessor's office, especially Jordan Marks, taxpayer advocate, and his boss Ernie Dronenberg. They take tax friendly advice to the next level. They're incredible people. So it's important to be in good communication with your family, because we own that. Yeah. Okay. So it's important to have to be on the same page with parents and children. So having the children involved in terms of transferring wealth to generation to become more financially mature and more involved if there's a family business, and so they might be more prepared to handle the transfer, and so that they don't lose motivation and become lazy and just expect that. So you want to make sure that they're able to handle that, especially if you're giving that during lifetime. And so it's incredibly important to have a good relationship, not only with your family, but with your estate planning attorney, tax attorney, as well as your financial advisors and CPAs. Having a good team involved can really make the best difference. And like I said, being in touch and in communication with the assessor's office is crucial, because if you are creating an irrevocable trust, and you're creating the irrevocable trust and it's out of your hands, a lot of estate planning attorneys that don't work with the assessor's office you don't really know if you have a good estate planning attorney until you're dead. So it's incredibly important. So when you have a proposal, a trust or an irrevocable trust, we would work with the assessor's office and run it by them to see if it's going to trigger a reassessment. And so if your attorney is not doing that, they should be, because you don't want to create any kind of uncertainty. So these are, the rules, the general rules have been through the ringer, but now we're in uncharted waters. And so now is when experience really matters. And, so this is where experience matters.
Thank you, Brian and Ronnie. You guys have been absolutely fantastic. I'm pretty sure my mom has a revocable trust, because every week she calls to tell me you're in or you're out. I don't know which one it is, but maybe I need to get her a irrevocable trust so I don't have to get the phone calls every week. But you guys have been absolutely fantastic. One of the questions that we get is, what if you leave it to all 3 of your kids, right? You have 3 kids. And I know that you have been working diligently on this. And I know that the assessors have too. And in San Diego, when we talked with you, we said, hey, there's no Brady Bunch rule here. If you get one of the kids in, we're going to be able to honor that. But you also said, hey, it's too often that we see people leaving it to all 3 kids because they don't want to insult one. And then when they buy each other out, they get reassessed, right? That it's not a sibling to sibling transfer. It's a parent to child transfer.
Exactly right. And
well, thank you.
I was going to just add on to that really briefly, that some people have in their estate plan that they just want to give everything equally, and that includes a house. And so you do have that situation. So if one child wants it and the other really don't care and they want cash, there has to be enough cash to equalize that. And so that's an incredibly important issue that is very common.
It just sounds like a ton of details that you need to sit down with your seasoned professionals and make sure you're taking into account, as you highlighted, the federal tax implications from the IRS, as well as making sure it's written correctly to actually achieve what the family wants and not just writing down what they say. Well, thank you, Ronnie. Thank you, Brian. You guys have been fantastic. Before we wrap up, we're going to get into one last part here. We have the senior disabled natural disaster victims and the benefits from Prop 19. Okay, so now you're ready for the senior part. Now you're like, okay, I took care of my kids. What about me? I'm interested. I want to move, but I'm locked into my home. Well, right now, the current rules before April 1st, that's the date you have to work by. Before April 1st, the senior exclusion, one time, you over 55, not my definition, that's the government definition, okay? Not my definition of old, but a senior for government purposes, 55, one time, you can replace your primary residence. That means it sells your primary home and then buy another one, as long as it's under the current cap, which is sale price plus 5% in the first year or 10% in the second year. And you have to do it within 2 years in the same county or within one of the counties that's adopted the Prop 90. Well, how do you know what counties are? There's 11 of them, but don't worry. After April 1st, it's statewide. You don't have to know which county to go to. It's statewide. Now, if you're over 55, again, not my definition, the government's, and you're a senior, you get 3 times. Before it was 1 time. Now you get 3 times. You get to replace your primary residence and get another one. And remember that cap? We saw a lot of people that could not transfer over their low property tax base. And you know what? Because they wanted to buy above the cap. No problem anymore. Now, if you go above the cap, which is your sale price, you get a blended assessment, still within 2 years. All right, so this is what it looks like. Hey, Sue's buying her home again. She doesn't look 55 and she's not, but let's just say you are for today's example. You buy a home for $300,000. The assessed value over time goes up $420,000 or a $4,200 tax bill. And Sue's like, I want to buy a home, but let me see. I'm selling my home for $900,000. Congratulations, Sue. That's a great investment. I'm going to buy below my cap, below my sell price. And she buys a place for $800,000. That's a potential $8,000 tax bill, which is way more than her $4,200. Don't worry, because it's below the cap, she gets to move over that $4,200 and boom, Sue saved $3,800 a year in property taxes. That's awesome. Now, Sue's been also working really hard over at the Board of Equalization office. So when she actually said, you know what, I actually want to buy something more expensive. I want to go buy a home for $1.2 million. That's not unconceivable these days. She's running the math at 1%. That's a $12,000 tax bill. Oh my God, you're gonna pay $12,000 when you've been paying $4,000 before. No, don't worry. This is how it works. It's your sale price, 900,000 minus your purchase price, 1.2 million. You add the 300,000 difference to your old bill and boom, your new bill is 7,200. That's a $4,000, over $4,000 savings, $4,800. So you can go below the cap and it stays the same. You can go above the cap and you add that amount on extra. And you've been able to upgrade your lifestyle without majorly increasing your property taxes. That's how it works. Here's some tips for you. Okay, some folks are now, I just sold my home. What do? I need Prop 19. Well, ask yourself, do you qualify under the old rules? If you do, don't worry. We believe, again, that term we believe, but we believe you're going to get 2 more times. But if you need to go above the cap, just close half your transaction after April 1st. That means buy or sell after April 1st, half of it, and then the deal will close and you'll qualify for Prop 19. Also, if you use a part of your property for commercial purposes, I know some of you are thinking, well, I grow stuff in my backyard. No, we're not talking about that, okay, unless you're selling it commercially. But let's say you rent out an ADU and you have landlord, and you're a landlord to some tenants. That portion of the property doesn't count towards your cap. So if 25% of your property is an ADU garage, then 75% will count to the cap. So just know there's a portion that doesn't count. Divorced couples, man, they used to fight over that low tax base to transfer over. I'm going to fight over the teapot, the cat, and my low tax base. Well, don't worry about that anymore. Now that you get 3 transfers, we're pretty sure each person in the divorced couple are going to get multiple transfers. Also, some of you out there are like, well, I just saw the parent to child. What about me giving my kids my tax base and then I'm going to go do my senior transfer? Whoa, whoa, whoa. You just gave it away. You can't take it somewhere else. So you can't do a parent to child and then a senior transfer. But you can do a senior transfer 3 times now and then do a parent to child transfer for their primary residence. Here's how it works. I had a realtor in Los Angeles. She had a low tax base, $500,000 or $5,000 bill. The home was worth $3 million or a $30,000 tax bill. What she did is she sold her home and bought a home here in San Diego with her kids, put them on title. Now you're like, are her kids under 55? Don't worry. Only one person needs to be over 55. Boyfriend, girlfriend, husband, wife, partner, whatever. It doesn't matter. As long as one of the folks are over 55, you can qualify. She added her kids on title. They bought a beautiful home for $3 million here in San Diego. She took the casita in back, had enough space for the grandkids, and boom, they now pay $5,000 in taxes a year versus $30,000 in San Diego. And guess what? She did a parent-to-child transfer before February 16th. So now the kids have functionality with the property. Okay, last 2 things. It's 2 deals. You have to buy, sell, and buy. You have to replace a property. And last, in San Diego County, we set up a specific email address to answer your Prop 19 questions. There it is. You're going to get the slides. And I want to say thank you to Vice Chair Schaefer, Gary, and the entire assessors from all across our partners in Southern California. We are here to help you. One last thing. A lot of folks are asking about COVID relief on their homes. The market's hot. It's really tough to find COVID relief. But if that value went below the assessed value on your home or commercial property, call us. All of the assessors are ready to help you with some property tax relief. All right, I'm going to turn it back to you, and then we have some questions and answers. And Gary, don't worry. I'm not over 55, but I still can't hear you. There we go.
Thank you very much, Jordan. I want to thank you, Jordan Marks, Ronnie Shamoon, and Brian Malloy of RJS Tax Law. Our office is downtown, just down the block from you. So after COVID, we'll come visit you. We see your sign every day when we go by. So I wanted to, we're going to go into questions. There's a lot of questions. A lot have been answered. And I want to thank Jeff Olson, Chief Deputy Assessor for San Diego County, for answering so many great questions on the chat. Thank you so much, Jeff, for doing that. I wanted to thank our hosts, the North San Diego County Realtors, for hosting this event today, since we had so many participants. Tommy Thompson, the CEO, James Santiano, and Lindsay Nightingale from the North San Diego County Realtors. They're dedicated, progressive, and committed to the future, and they're located in Vista, representing North County. Thank you, North County Realtors, San Diego North County. We appreciate you very much. Okay, so now we're going to go to questions.
Hey, Gary, the number one question we're getting is, are they going to get the slides? And the answer is yes. Don't worry. We're going to email you the slides afterwards.
We have everyone's email if you have registered, and we will be sending you all this information this afternoon. Okay, so and then we're going to have email addresses for you to contact your local assessor as soon as we wrap this up. So let's get into the questions now. So we have a question from Rena. What about multifamily rental properties?
Okay, so remember, before February 16th, multifamily property, commercial property is in the other category. And as long as the assessed value of that is below 1 million, you can transfer your kids the entire portion. Now, what if it goes above 1 million? Then we go based on a pro rata adjustment based on percentage. But after February 16th, you cannot give your kids the commercial property with the low tax base. You get reassessed when you give it to them. Unless, I'm going to say this, let's say you have a duplex and your kids reside in half of the duplex, then half of it can count as their primary residence. But if you have commercial property or apartments and you have a very low tax base, and we see it all the time, now is the time to act, because that will eat into your bottom line. Do it right. And like Ronnie and Brian said from RJS Law, make sure you're transferring in a way that does not lose that step up in basis, because as they said, it might cost you more in income tax than you're going to save in property tax. You have to balance that out.
And then Jordan, I have a question. I'm sorry, but this is a big question that everybody's asking. And the question is, what if you can't get it recorded by February 16th? What methods will suffice? Will the proof of receipt of mail suffice, or must it be recorded? Because there's a lot of recording companies and people out there that are not taking this right now. So that's a big concern for people, is the recording. If you could dabble in.
And we know that being closed for over-the-counter services during COVID has been an impact on everybody. And honestly, in San Diego County, and I'm sure I could say this from my other assessor colleagues, we are trying to communicate every way we can. Email, electronic. I tried to chase a carrier pigeon the other day. I couldn't catch it, but I'm pretty sure it had a recording document on it. But I will tell you this, for San Diego County, and I'm only going to speak for San Diego County now, because some other counties have interpreted that you need to go by recording date. There are counties out there, I want to warn you. But in San Diego County, we are the assessor recorder office. We are going to go by the acknowledgement date, or that's the date that you notarized the document and delivered it. That's what we consider legal change of ownership. And so I'd encourage my colleagues from the other counties to mention if they're different, Assessor Menville, if they know different over there, or Peter in Riverside. But right now in San Diego County, don't lose your mind over having gotten it recorded on time. We have record high recording right now. It's crazy. And some of the companies are not servicing. You're right. We're going to go by the notary date and delivery. So as some of you looked on your calendar already, April 15th is a holiday. It's crazy. We're closed that day. Don't worry. As long as you meet with your notary that day and you have the acknowledgement and delivery. And remember, like I said before, you're not delivering to Jordan. You're delivering to the person that's getting the benefit, your kids. And then they record it afterwards. They have technically up to 3 years to record and file their parent-to-child transfer. Don't wait 3 years. Do not do that. It makes it harder. Do it right away. But we're not going to hold you to that recording by the 16th.
Thank you, Jordan. That was amazing.
Assessor Menville, Robert, can you tell them for Imperial County what you're doing?
As far as the recorder's office?
What's your understanding? Yeah.
Well, I'm not the recorder, so I would I'd have to defer to Chuck on that upstairs. I could call upstairs and ask them if you want.
That might be good for the
Okay.
people from Imperial County. Yeah, thank you.
Sure.
Okay, appreciate it. And then we have we have Sean Downs, who's on from the Riverside County Assessor's Office. Sean, do you have an answer to that question?
Yeah,
I
Riverside County will also accept the date that was signed and notarized for Prop 19 purposes.
Okay, perfect. All right, so now we have a question from Bin, B-I-N-H. Can I transfer my real estate properties to an LLC and then put the LLC in my current trust dated 1994 so that the property tax will not be reassessed after I pass away?
So there's two parts there. One, LLCs did not raise your kids. They're not human beings, as Brian pointed out earlier. LLCs are a corporation. So you cannot transfer from an LLC to a child. It has to come out of the LLC, and there's a way to do that without getting reassessed. And then you can transfer to your kids, and then they can put it in the LLC. The second part of that is, you're just because you created the trust in 1994, the actual change of ownership still has not happened. And it sounds like you have a revocable trust because you can move things in and out. And as Brian said, if it's in a revocable trust, like my mom calling me every week saying you're in or out, you're in or out, well, then you can't have considered that a change of ownership. It's only upon you actually giving them the property and you have no rights or benefits to it, can we consider that a change of ownership.
Okay. Now we're going to move on with some title issue questions. The most frequent title question from the questions submitted before the forum when you registered: should I put my kids or grandkids on title to my properties prior to February 16, 2021?
Again, we're going to have to look at your specific address and your specific situation. You have to look at your assessed value, and you have to look at how much the taxes are going to go up. You have to look at, like RJS law said, you have to look at the capital gains implications. So if you put them on title to any percentage, that's the percentage that they're going to save. So if you put them on 1%, then we transfer 1% of the property taxes. You don't get everything. And the savings for them for federal purposes is 1% will get counted towards the income and capital gains. Brian should probably confirm that before but generally, right now, I would say you have to look at your exact situation. You have to sit down with your professionals, and we're going to have to know the details. It's like telling me, should I buy this cow? Well, I don't know. I haven't looked at it. I got to stick my hand, places and look at things.
Okay, Cindy asks, if one sibling buys out the other two siblings' interest in the recently deceased parent's home, the value is under $1 million, can the remaining sibling, who now owns 100% of the house and who will be living there as his or her primary home, rent it out to two other people to subsidize the mortgage?
So I think I heard that you were buying your sibling out there. And so I just want to remind everybody, it's the parent to child transfer, not the sibling to sibling transfer. And in that case, we would reassess that portion. Now, prior to February 16th, you can rent out that property for commercial purposes. After February 16th, it has to be your primary residence. Now, can somebody rent out a portion of their primary residence and still maintain that low tax base? We believe that to be true. You got a foreign exchange student, bring them in. I don't think it's going to invalidate and you're going to lose your homeowner's exemption. Again, there's the term we believe. Now, if you rent out 3/4 of your property and it's no longer your primary residence for that purpose, you could be in jeopardy of losing that transfer after February 16th.
Andy asks, I currently live in a house in my father's trust. The mortgage loan is in my name. What is the process to put it in my name to keep the current property tax rate moving forward? And is there any tax liability doing this?
So you would go to our website or any of your assessor's websites. On the San Diego County website, we have a sample deed, a grant deed, or a quitclaim deed. You would file that. You would also need a preliminary change of ownership. You'd have to put what's called an SB2 recording fee that would exempt you from recording fees. All of these are on our website, and you can email our office and we'll send you the exact links. But the biggest part is if your dad puts you on title, you're going to lose what Brian referenced and RJS talked about, that step up in basis. So if your dad bought that property for $250,000 and you don't take it from him at death and it's worth $1 million, you're potentially paying $750,000 in capital gains tax, right? Brian, if you want to kick in on any of this, but that $750,000 at a 20% tax is going to be potentially far greater than the property taxes you're going to save by transferring it now. And if you're already living in the property and you're going to stay there, and if it's your dad's primary residence, then they can transfer it down to you.
Right.
Okay.
If the property is not going to be sold for a generation or two, then that's okay. But when it is sold, that's when you're going to hit you.
Watch out for the IRS. They're always hunting for you and you need to have good defense.
Yeah, they're aggressive.
We have a base year transfer question from Ashley and Victoria and others. How will you handle the straddle sale issue of a primary residence for someone who's 55 or older? That is, if you sell or close your primary residence prior to April 1st and you buy or close a replacement property on or after April 1st, can you still transfer the tax base? And Mike asks it in this way: can a senior who sold in 2020 transfer the value to a new primary residence in 2021? Is that senior bound by the old rules, or does the senior fall under the new Prop 19 rules?
Well, as I said in my tips, if you buy after April 1st, that means if you do half the transaction, buy or sell after April 1st, we believe, and in San Diego County, we're going to honor that will be under the new Prop 19 rules. And I think Assessor Menville might be able to comment, and I know Sean for Riverside, but we believe that pretty uniform. If you do half the transaction, that means you actually qualify by doing after April 1st, then you would be under the new rules. Sean or Assessor Menville, do you want to comment on that?
Yes, in Riverside County, as long as either transaction happens after April 1st, they would be able to transfer the base value.
I think Assessor Menville give a thumbs up to say that's the same in Imperial. So now I saw a question pop up, what about stepchildren? Well, remember I said you had to be under 18 to qualify to be adopted and get these benefits. Stepchildren count as long as they're still your stepchildren through legal marriage. If you separate from the parents, they're no longer your stepchildren legally.
Okay, thanks, Jordan. Regarding rental properties, Ping asks, how will Prop 19 affect rental properties? When rental properties are passed from parent to child, the property tax may increase significantly. How will the new landlord, the child, handle this situation? And what will happen to tenants if the new landlord cannot make ends meet?
Well, there's a lot attached to that, but unfortunately, that's going to take some very specific answers. Each jurisdiction in California has different rental rules. And so you're going to have to decide what are the rules and how do they apply in your jurisdiction. And so if you want help with that, please send an email if you're in San Diego County, prop19@sdcounty.ca.gov, or I know Gary's going to flash the information for each assessor's office, and we can get you connected with the right people. But for the rental rules in each city or jurisdiction, you're going to have to actually go to the city or the county that you're operating in.
Will, let's flash the that information for soon for all the counties, for people who need to leave the call. So Jennifer asks, I am dealing with a multi-unit property that will be passed down via a living trust from father to daughters. Will one daughter need to live in an apartment unit in the complex to avoid the tax reassessment? Also, what are your thoughts on putting the complex in an LLC?
So remember, if it's in an LLC before, that means parents haven't given it to you yet. They can't give it to you from the LLC. They're not your parents. It's a corporation. But if you want to put it in the LLC afterwards, that's fine. And there's ways to pull things out of LLCs without being reassessed. Now, really great question. So let's say your parents have a 20-unit apartment building. Before February 16th, they can give you the whole assessed value as long as it's under $1 million on that building. After February 16th, if you reside in one unit of this 20-unit building, only one unit counts as a primary residence, and we can transfer down that portion if it was the primary residence of your parents before they gave it to you. Otherwise, I'm sorry, that benefit of other property is expired.
Okay, capital gains and stepped up basis. Jacqueline asks, how do the children protect themselves from paying capital gains on the sale? Can it be put into a trust or an LLC to avoid capital gains?
So if it's not put into an entity and it's sold, then if it's sold by the child, they're going to pay the capital gains. There's not going to be a step up in basis. So they're going to lose that. So now certain trusts can be utilized as well as certain other certain other tools that can be utilized, but it's very, very specific to the situation. So it really depends. There's a lot of moving parts, and but there's likely going to be a tax.
Most likely the capital gains taxes will have to be paid.
Yeah, by someone.
And I think Brian did mention the irrevocable trust, if it's written correctly, could be a tool to help you avoid the loss of step up in basis for IRS purposes and still have the low tax base transfer over. But I know Brian's going to ask you to pull out the assessed value and also look at the value of the buildings. If it's over 11 million or 23 million, or if it's over $1 million of assessed value, they're going to help you weigh these things out. You have to have specifics when you're getting to the right answer for you and your family.
Next question, Greg. If my mother passed away in 2000, but the 180-day waiting term is not finished yet, will the tax of Prop 19 affect me if I'm selling the house later this year? I was told to get step-up basis, but it's not sold yet.
So it sounds like there's an IRS question about the parents passing in 2000, but for our purposes in property tax, before I turn it over to Brian, date of death is what we operate by. So if your parents happen to pass away on February 15th, and please don't go and push your parent, no, just joking. But if something happens to the parents before February 15th, then that's the date that we operate by. And Brian, did you want to comment on that for IRS purposes?
Sure. Yeah, it's when the rights of the beneficiary vest upon death. And so when the trust becomes, it's a revocable trust, and when it becomes irrevocable and the rights of the beneficiary vest, that's when the person has the right to that property.
Okay. Daryl and Dutch both asked, how does Prop 19 affect historically designated property?
So under that, we have what's called the Mills Act. And the Mills Act has actually 3 types of valuations. There's a Mills Act calculation, a market calculation, and a Prop 13 calculation. I know this is really crazy, but on historically designated properties, the cities can allow you to reduce the property taxes potential. We choose the lowest of the 3, but it still has a Prop 13 value on it, and we honor that value and we transfer that over.
Okay, next question from many people. Because of COVID-19, the pandemic, it's greatly affected our ability to communicate with legal experts. Could we get a reprieve from Prop 19?
So this was passed as an initiative by the voters, by you. You tell us what to do. And this is your action of saying, hey, I agree to the rules that were in the initiative. And unfortunately, the initiative says February 16th. That's the date we got to go by. Here's the issue, though. Some folks in the legislature are like, well, we want to remove it, but they can't legally. So because it's the rules that you passed, unfortunately, there's no reprieve from your own guidance.
Thank you. And I do want to point out that, as we said in the beginning, the Board of Equalization and Vice Chair Mike Schaefer, the California Assessors Association, led by Assessor Ernie Dronenberg, are working hand in hand with the legislative leaders to clear up some of the ambiguity and questions in the law that was passed. And we're doing that before some of these deadlines. We're working with the legislature. It's an ongoing process, but we want you to know we're doing that. Unfortunately, as Jordan said, we can't get rid of the law because it was passed by the voters.
And Gary, one of the questions I get is, can we bring it back? And the answer is yes. And I know the Howard Jarvis Taxpayers Association is currently looking on how to bring back portions of Prop 58 and reinstate them. The earliest we're going to see that is within 2 years that they could do that. But the same way that you voted to get rid of something, congratulations, you have the power of a voter in California to bring it back.
But the problem is half the time the voters don't even realize what they're voting for. The way these propositions are described is they don't realize what you're really doing. You know, money for schools, money for firefighters, and not realizing, like the gas tax. You know, most people, you know, voted for that not realizing what they were voting for. And I think a lot of people with Prop 19 didn't realize what they're voting for. It's the descriptions of the propositions that there needs to be regulation on. But it is what it is, and we have to live with it now.
So Joanne and others, we will tell you again. She asked, can we get a copy of this chat with the questions and then the answers? We will be getting, you'll have to ask your specific questions that have not been answered with the emails that you will get when we send you out these slides, okay? And you'll have to check with your tax professional. We put this together rather quickly because we knew this is important to share as much information about a really complex subject. It's even confusing for our people who are tax experts. I'm sure even with the RJS law firm folks, it's very confusing. So,
Gary, we got a question from Stephen Wilcox. If he has a
Yeah.
commercial investment property and he does nothing, will his tax base change? The answer is, Stephen, it won't change. As long as you're alive and as long as you don't change ownership on that property, and for everybody out there, your taxes aren't going to change. The only thing that changes is how your kids can receive it, if they can at all, or what it will look like for your family in the future.
Okay. Well, we're at 1:40. We'll answer a few more questions and then I guess we'll wrap up here. Let's get some that are from the chat here that haven't been answered. Let's see here. Me and my wife live in a house that is in my father's well, we've answered the revocable
Gary, I
trust,
see
but
a
it is
question
not.
out there. Can I lease a property for longer than 35 years? And that was a really interesting question that we received. It's called a long-term lease. And for California property tax purposes, if you have a lease longer than 35 years, it's considered a change of ownership. But at the time that you pass, if there's not 35 years or more left on the lease, then the property ownership reverts back to the owner, which would be your parents, which would be against what you're trying to do here. But if there's more than 35 years on the lease at the time that your parents pass and you are the holder of that lease, then the ownership collapses and we don't reassess. And also your parents still get to have ownership for the purposes of a step up in basis for IRS. So good professionals and estate attorneys, and I know we worked with RJS on this, they know about the long-term lease and it is an option, but it depends on your property and what your estate is working through.
Okay, a title question from Andy. I currently live in a house, my father's trust. The mortgage loan is in my name. What is the process to put it in my name to keep the current property tax rate moving forward? And is there any tax liability doing this?
So the answer is there's no tax liability from the property tax, but there is federal income tax liability. You'll lose that step up in basis. And so I'm sure a creative person like Brian might look at the property and say, hey, why don't you sell it to your kid and not do it for the amount above which you're going to pay income tax, and then give them some small step up and then forgive the loan with the estate. There's ways to do it, and you have really smart tax professionals. Also, one of the questions I just saw is, how will my QPERT be trusted? That is a type of trust, and QPERTs do not qualify as a change of ownership. So if you are in a QPRT trust, you must move it and change ownership if you want to take advantage of the rules before February 16th. And I see our friends at RJS look like they want to add some comment on that last point.
I don't. I'm sorry, I wasn't paying attention.
Oh, no. It looked like Brian had another tip for our viewers.
No, but yeah, for QPERTs, you're going to run into trouble, unfortunately.
All right. The question is, how do you properly complete the PCOR? That's the preliminary change of ownership when a trust is established. Okay, so remember, if it's a revocable trust that Brian talked about, you're not doing, you're going to do a change of ownership into the trust from the individual. A preliminary change of ownership report is what's recorded with the deed. So when you deed the property to the trust, you fill out a PCOR. And guess what? Great news. When you go to our website and get the PCOR form, there's also an instruction sheet that goes with it. And if you email our office we will send you out both. And remember that there are recording fees exemptions that are allowed. So if you're giving your kids property and it is a residence, you can be exempt from what's called the SB2 Atkins fee. That could be up to $225. So talk to our office, ask us for the forms. We'll walk you through it and tell you what each accomplishes without giving you legal advice. We are all prohibited from providing you legal advice, and that's why Gary gave us that fancy disclaimer at the front of this presentation.
Yes. I did want to tell you that we had another member of the Board of Equalization, Malia Cohen from San Francisco, who's joined and is listening and says she's loving this and she thinks it's an excellent call. So we appreciate you, Malia Cohen, for joining us and supporting Vice Chair Schaefer in this program today.
Gary, we have a question here from Deborah Jarvis. Her husband's 55, so they're doing a senior transfer. They sold their primary residence on February 1st. Okay, you just sold it, congratulations. And they're looking in San Diego County to build a home as our primary residence. Here's the tough part, Deborah, you have 2 years to build the home. So that's the way it works. If you can't build the home and you get that certificate of occupancy from the county, because Fallbrook is in our county land, then you can't qualify for the parent-to-child transfer. So again, remember, because it's a replacement property, the home just has to be built, and after April 1st, if it's more expensive, you will qualify. And the 2-year period started at the time that you sold your home.
Okay.
I have a question here. Is the 11.7 million in inheritance for federal tax purposes per child, or is it no matter how many children there are? Brian and Ronnie?
It's for the person that's passing away. So it's, you have the $11.7 million exemption. So, you know, whatever property that you have, if it's more than $11.7 million, it could be subject to taxation.
So each parent has 11.7 million. If there's 2 parents, that means you get double that, right?
Yes.
Correct. And so
No matter how many kids you have.
that's right. And each kid has their own 11.7.
That's really tough for those folks that have 8 kids. But then again, if you have 8 kids, you might not have 11.7 million in the bank. All right, appreciate it. We got a question. What about a revocable trust after February 16th? Remember, if it's in the revocable trust, it didn't qualify for a change of ownership, but the taxes haven't changed, okay? It's the future taxes when they get to your kids that will be impacted. Can you tell me the difference between Prop 19 and Prop 6090 in regards to the tax-based transfer from my previous home to my current home? Okay, this is the difference. Prop 6090, they're the same, it just means between different counties. If you're over the cap, which was the sell price plus the 5 or 10% beforehand, that's Prop 6090, you don't get to transfer it. Now, under Prop 19, you don't have a cap and you get to transfer it 3 times.
So I have a recording issue question from Mara Cruz, Kathy, Jennifer, Wendy, Richard, Patrick, many people. If a parent has previously signed a deed to their children prior to the February 15th deadline, but it has not been recorded, will it still qualify for a parent-child transfer exclusion? In other words, does transfer of property between parent-child occur when the deed is signed and notarized or upon recording? Well, I think you answered that.
Great question. Remember, it's upon notarization and delivery, but that's in San Diego County, Imperial County, and Riverside confirmed that today. But for those that are in other Northern California areas, some counties have taken a belief that it should be based on the recording date. So we have another question here. How does this affect my vacation home?
Robert Menville, George.
Hey, Robert.
Yeah, I spoke to the assistant recorder and she said she could not confirm Imperial County's accepting acknowledgement. She's going to check with Chuck Story and get back to me.
This is why we need to check in with our recorder folks, but at least we can confirm today, Riverside and San Diego County, if you go ahead, we will accept the notary date and the delivery. But this is where it gets really tricky and why this information and working with professionals is so important. Okay, we got a question. How does this affect vacation homes, a second home, when the parents will leave it to their children? So remember, vacation homes are other property. You only get other property before February 16th. You don't get to transfer it after February 16th. So after February 16th, your kids will pay taxes based on the market. So if it went from that $1,600 to $2 million or $20,000, after February 16th, they'd be paying $20,000 taxes a year. And we got a question here from Carol. Can you review step up in basis versus assessed value? So I'll go over assessed value, and then Brian's going to talk about step up in basis. Assessed value is that Prop 13 locked in rate. That's your purchase price with the 2% increase. That's the amount on your tax bill. Doesn't matter what the market value is. That's the assessed value. And a step up in basis for IRS purposes, those are your federal taxes. Brian?
Sure. So a step up in basis is Internal Revenue Code section 1014, and that just states that, let's say for inheritance, if you inherit a home, it's going to be the fair market value as of the date of death is the step up in basis. So if you turn around and sell it the next day, there would be zero capital gains tax. But if you do not have the step up in basis, you would pay the same capital gains tax as your parents would if they sold it.
Okay, great question. Once I'm over 55 and I received a parent-to-child transfer, parents left me their low tax base, can I do a senior transfer with it? The answer is yes. So while we talked about potentially if you rent out your home after getting it for a parent-to-child, and you have to have the residency, the senior transfer portion doesn't have requirements. So if you do a parent-to-child and then you do a senior transfer, you could then rent that property out. That's if you're over 55 and still keep that low tax base.
So friends, I'm just going to share that we still have between this and Facebook, we have over 400 people. So we're going to spend 10 more minutes trying to answer more of your questions because there seems to be still a lot of interest and getting a lot of positive texts about the quality of the program. So thank you to all the panelists.
Okay, next question is from Wendy Jones. My son bought a condo with his mother to live in. How will that affect his property tax? Remember, I talked about that in my tips. If you bought a property with your son and you're on title, you can come off title without any tax hit because you can use it under the other property. Do it now before February 16th. Next question. Can a parent lease a property for a child for over 35 years prior to triggering the change of ownership? Yes, that's the lease option we talked about. Again, this is not amateur hour time, folks. It is time to work with a professional to protect yourself because there are a lot of intricacies attached to this. Okay, mother buys a condo for daughter and puts her on title. Should the mom take herself off title? Some people like to have their parents on title for protection because remember Brian talked about probate. Probate's a jail. It's hell. You don't want to go through probate. And some way that people protect themselves is they add them on title. But if you add yourself on as joint tenants, that means if one of you die, the other gets it. We reassess at that point. All right. Will Snyder asks, for IRS capital gain purposes, I thought when the owner of the commercial property dies and makes a bequest to their kids, then the kids get a stepped up in basis on commercial real estate. Is that correct? Yes or no, Brian?
That's correct, because section 1014 applies to all property, real property as well as personal property. So real residential, commercial, even stocks. So all property.
All right. We have,
One
you know,
question.
I'll tell you, when I hear tax codes, it's music to my ears. That means you're being protected.
Yes. We have a question from Josephine, general Prop 19 question. How long do my heirs have to live in the house, live in my house once they inherit it to secure the Prop 13 tax base? I hear they have 1 year in which to move into it and make it their permanent residence, but how long do they have to stay in it?
The answer that we believe is as long as they stay in it, they're going to get it, that tax base. Otherwise, when they move out, we will reassess it based on the date that they received it. And this is an interesting fact. Thank you for bringing this up, Gary. Residency issues for IRS purposes are different than California property tax. For IRS purposes, to get benefits, you have to live in the primary residence for 2 years, like Brian said, and you could switch every 2 years. For California property tax, residency is based on when you tell us that day, and you declare under penalty of perjury with a homeowner's exemption that that's your primary residence. So you don't have to be in there for 2 years to qualify. You could be in there the next day in the property, or 30 days after you get it, or 60 days after you get it, and just declare that day your homeowner's exemption and you're good to go. Okay, during the 2-year window for selling my primary residence, do I jeopardize the ability to transfer the property tax if I rent out my house during the 2 years? Well, it depends. Okay, you still have to have it as your primary residence. That means you live there for more than 6 months. You are allowed to rent out your property, but at the time that you file for the senior transfer, it has to be your primary residence at that point. So there is some flexibility, but run that by your assessor's office. If you're renting it out for the year, sorry, that won't qualify.
Jordan, we have a question from Wendy. I just bought a condo for my daughter. We are both on title. What should be done regarding Prop 19? Is it helpful for me to be taken off the title of the condo?
Remember, when you're on title, if you come off at any point, then it gets reassessed. But since you're on title, you know, let's say you're 85 years old or 90 years old and you're like, I might pass soon. Well, your kids might get a step up in basis, but just remember you just bought it, so that basis isn't worth anything. What you're more concerned right now is about reassessment for property tax purposes. That's a great question. The answer is come off title under other property before February 16th, because that ability to do so goes away. I have another question about all my children are minors. Can I transfer title to my minor? The answer is yes. Did you have any comment on that, Brian, as far as federal tax purposes on minors?
Not necessarily with respect to tax purposes, but it has to be, you know, structured in such a way that for purposes of the minor of owning property.
Okay, Rena asked, does Prop 19 have the provision to increase that million exemption as property values increase? The answer is yes for the parent to child portion. After February 15th, you get that million of market value. So that answer is yes. Okay. Can you preserve the property tax assessed value and step up in basis by gifting 51% of the trust to your child before February 16th? The answer is no, because you're giving away 51%. And so you lose 51% for step up in basis purposes, and you only give them 51% for property tax purposes. It has to be total ownership.
We're ending in 3 minutes. Lydia asked, will Prop 19 affect taxes if you are a disabled military retired veteran and have 2 properties?
Well, it depends on those properties. And so we're going to need the specifics on that, and we can help you. But just in general, for the disabled veterans exemption, it does not impact that. One of the questions we have is our county assessor's office is currently closed. Don't worry, we're not closed. We're just not open for over-the-counter services. So remember, I tried to chase a pigeon around our office. It's because I'm here at the office. But look, seriously, our phone centers are open. Our emails are open. I mean, if you didn't see Jeff Olson answering so many questions on this chat box, we're in the office and we're working to make sure that our tax roll closes. And you could see Robert on the screen in his office. And I know Sean and the hard folks in Riverside are working there. So give us a call. We're replying to emails. We just happen to be closed for over-the-counter services due to COVID. My mom is 90 years old, and the house, her assessed value is $56,000 or a $560 bill, and the home's worth $700,000, or that would be a $7,000 bill. Since the worth is less than $1 million, should we transfer the title now to her child that would make it her primary residence, or should we wait until her death? I would say, it sounds like Brian was saying, wait until she passes, because under the primary residence portion, you're not going to see your taxes go up. So from a county assessor perspective, on that example, your taxes won't go up and you're going to live in the property. So no problem. Transfer those low taxes over. And Brian, do you want to comment on the capital gains issue? What benefit they would get if waiting upon mom's death?
Sure. So if at mom's death, the property gets a full step up in basis, so it's the fair market value. So if they sell it immediately thereafter, there's going to be no capital gains tax. And
that sounds like it would be capital gains on almost $500,000. At 20%, that's $100 grand. I think it's worth the wait. Don't do anything. You're good right now.
Principal,
Almost. will assessments for future years be limited by 2%? I think he meant Prop 13 cap and the Prop 19 value factor and assessment only price. Okay, so did Prop 13 get altered by Prop 19? The answer is no, it's still the same rules. It's just now,
So-
under Prop 19, we look at market value in the future versus assessed value now.
So Jordan and Brian and other panelists, Cristobal asked, how does Prop 19 affect foreign nationals that have property in California?
Great question. Well, some foreign nationals are able to have residency here. It depends if they have a green card. And if this is their primary residence and their kids are here, this will impact them. So the same rules will apply. Now, if it's your other property, okay, now let's say this is your second home, okay, you reside in another country and you have a vacation home here in California, well, then you're going to be impacted because after February 16th, you don't get that other benefit. And since it's not your primary residence, that's the only benefit that transfers afterwards unless it's a family farm, okay? So for those folks that this is their second home, vacation town, you don't live in it and you don't live in the US, the benefit is a tremendous loss if you don't transfer it now. But again, for tax purposes, and Brian can comment, they might have international tax implications, something that we're just not going to dig into today, but it could be possible, right, Brian?
Right, there could also be immense estate tax issues with that, with non-citizens. So, but with proper planning, you can help with that. But if there's no planning, the IRS is going to crush you because the exemption is way lower.
Question, what
So
if the
here we are.
vacation rental cannot be a primary residence because of a 100-year lease on forestry land? Parents own the building but not the land. That's called a possessory interest, and that's a whole different ballgame. Email your question to that county assessor, and we're going to help walk you through that.
So we are at 2 o'clock and.
Gary, do you think that you might be able to put up the slide again with the county assessor's contact information?
Unfortunately, my deputy is out of the, he is using the facility, so I can't do that right this moment. So we'll wait for him to return. But we will be sending that out with the slides as the first thing this afternoon, later this afternoon.
Or maybe
Okay.
since we have Assessor Menville on, Assessor Menville, what's the best email address that somebody can email you in Imperial County? And then Sean for recorder, Sean for the assessor for Riverside afterwards, maybe they can let everybody know.
And it's Imperial County Assessor, ASSESSOR at co.imperial.ca.us. And if you go to our website under how to contact us, that email address will be there.
And they're asking that you put that in the chat box if possible. And
Sure.
Sean, would you be able to say it and put it in the chat box for Riverside?
Sure. The Riverside phone number is 951-955-6200. And the email would be accrmail@asrclkrec.com. I'll type that in the chat box.
And then I'm going to ask
want-
Jeff
I wanted
Olson to
to-
drop it in the chat box for San Diego County, but we set up a special one for Prop 19, and we've assigned our 4 top tax experts to help you. That's Prop 19 at sdcounty.ca.gov. And again, until Prop 19 gets implemented on February 16th, we'll be answering those questions 24/7 with our top 4 tax experts.
Jordan, this is Vice Chair Schaefer. Do we have a phone number for Orange County and San Bernardino County in case somebody out there is watching where they can be directed?
Well, and I think Gary told me, Vice Chair Schaefer, that then the email where they send out the slides, they're going to include in that the contact information that everybody just heard. But it was probably good just to say it so in case folks wanted to write it down right now.
Sure.
We've
Because
got a great team that thinks of everything.
yeah, we're serving all 5 counties. You know that, of course.
Of course. And as you know, we invited the Orange County Assessor to participate, and he was unavailable. But we will be passing on information because we applaud the counties that are providing such great customer service to the taxpayers. So I think we're coming to a close here. I want to thank everybody for joining us. I appreciate the text messages I've received, people saying that this has been great. It has been excellent. And I want to thank all the panelists, all the assessors, from Ernie Dronenberg to Peter O'Donnell to Robert Menville, and the Vice Chair, Mike Schaefer from the Board of Equalization, and the other folks here. I want to in particular thank Jordan Marks from Assessor Dronenberg's office for his tremendous help in putting this together and being so knowledgeable. He really has done a tremendous job, and Will Rodriguez Kennedy from our office has really stepped up to put this on in basically 4 days. So thank you all for participating. By 5 this afternoon, we will send you the slides with that contact information, and basically you have 1 week to reach out to your tax professionals, look at the slides, and really figure out carefully what you want to do. But we appreciate your participation, and we will do these in the future as well. Thank you
This
so
is
much.
Vice Chair Schaefer. I want to thank all of my staff and thank Ronnie Shamoun and your assistant for being with us too.
Thank you so much, Mike.
Thank you very
All
much.
right.
I also
Look,
want,
everybody, we're here to help.
I just want to say, you know, the assessor's office can be your best friend, and I just can't say enough good things about Jordan Marks and Ernie Dronenberg's office. They've been a tremendous resource for me and my clients, and it's just been a pleasure, and they're here to help.
Thank you very much. And we thank RJS Law Group for participating. And we appreciate Jeff Olson, the Chief Deputy Assessor, for answering so many questions in the chat. And he spends all day long answering questions. You're doing a tremendous job, Jeff, and we appreciate it. We appreciate you, Assessor Dronenberg. And we appreciate the North San Diego County Realtors for hosting this event. Thank you all so much, and have a great afternoon.